Once we start studying law of air, you have already learned that there are two important zones, national airspaces and international airspaces. National airspace and international airspace, both of them have an importance related to communication and transportation. And they are bound by different regimes. National airspace is the airspace above the territory of one state. And you know that territory is terrestrial territory and maritime territory. So the entire air above normal terrestrial territory plus territorial waters is assumed as the national airspace of the sovereign state. And the state has absolute sovereignty in its airspace. International airspace is that airspace in between national airspaces. So it means it's actually the air above the high seas, international waters, exclusive economic zones, and what else? Continental shelves. They're all perceived as international airspace. National airspaces, they do not have innocent passage freedom, like in the seas. In the seas, that passage is always open, uncontrolled, as long as there are certain concerns related to health issues, for instance, epidemics and so on. We have already studied it. Here, innocent passage is not a case, but nations are still trying to keep their national airspaces as much as open to all other nations. Still, a permission is necessary for all flights. And what I am talking about is civil flights, of course. We're not including military flights. Military aircrafts do not enter to the national airspace of each other. So they remain only in their national borders. In international airspace, we can talk about freedom of passage or freedom of flight. Of course, this zone is marked by freedoms, but this should not mislead you, thinking that then the pilot can take the aircraft wherever she or he wants. Then accidents may happen, of course. So they still need to define which air corridor they take, which path they're going to follow, at which height they are. So they're free, but they need to indicate their paths and corridors and altitude and so on in order to prevent any kind of accidents taking place. This part is completely open, therefore we don't have also limitations for military devices, military aircrafts as well. And that freedom, high seas are marked by freedoms, we have said. As you remember, states are allowed to conduct, for instance, research, but they cannot pollute. So there are limitations. International airspaces are also marked by freedoms. The only limitation is peace. They should not be, the flights should not be spoiling the peace, security, and benefits of other states. So the usage must be beneficial. Only for utility reasons it can be used. For international law of air, we have two legal sources here for this class. There are actually multiple sources that you can learn, but I have included only two sources. One of them is a very old source actually, that dates back to 1919, the Paris Convention. And the next one is the Chicago Convention of 1944. 1919 is quite important because this is the first time in which sovereignty of the states on their airspaces is recognized. That's why. And 44, Chicago Convention's importance is that it has established one intergovernmental organization that's known as, we have mentioned it in this class, International Civil Aviation Organization. Let's start with 1919 Paris Convention. According to Paris Convention, first of all, as I have mentioned, the sovereignty of the states over their airspaces is recognized. This is acknowledged by this convention. Therefore, nations, they have the right or deny flights in their airspaces. And another important principle according to 1919 Paris Convention is that nations are called to implement equal airspace rules for their fellow states. And they're also asked to implement as much freedom as possible to their fellow states as well. So there is no innocent passage right mentioned here, but it says that, okay, you're going to give permissions, try to keep your airspace as much as open to other civil flights. And those permissions are given in a bilateral manner. So states conduct with each other certain negotiations, and then they decide upon how those flights are going to be conducted. It says that aircrafts of contracting states are to be treated equally. So when states make diverse treaties, still their airplanes have to be treated equally. And 1919 Paris Convention also says that aircrafts are also supposed to have nationalities. And how is that going to be determined? The nationality of an aircraft, can be determined according to the state the aircraft is registered in. All right? So you know that ships are also registered. And this is the case also for the aircraft. Wherever they're registered, this is perceived as the nationality of that aircraft. Why is that important? Yes?
There is a crime in not only in the national airspace, but also in international airspace. There should be a punishment.
True.
To make it up.
For two reasons, you're right. One of them is directly related to what your friend has said. This is directly related to jurisdiction rights on that aircraft. And secondly, we have said that states are making bilateral agreements related to flight permissions in their airspaces. And for instance, if there is no agreement in between Georgia and Turkey, then an airplane coming from Georgia, we know that there are no permissions given to them, for instance. Therefore, to define according to which agreements, which flights are being done, that nationality was necessary. Any questions until here?
You just said the second one is just if there is no bilateral agreement between states.
So this is actually nationality is necessary in order to determine if any flight agreements are concluded in between nation states. So actually, law of air and law of space are new branches of international law. And 1919 is the first agreement, and this is as a result of the advancements in the aviation, of course. Airplanes have started to take off a lot from diverse states, and this was necessary to be regulated. And before 1919, what has happened? Those 4 or 5. The World War has taken place, and there was a necessity to regulate flights so that when an airplane enters into the national airspace of another state, this will not be perceived as a threat. That's why it was necessary to determine. As for the 44 Chicago Convention, this convention has established an intergovernmental organization, International Civil Aviation Organization. This is a very special organization and very specialized organization. This organization is working hand in hand with the United Nations. And its work is completely excluding the military flights. It only concentrates on the civil aviation. Civil aviation means carrying passengers, carrying post, or carrying cargo. This is known as, or private jets are also considered like that. According to this agreement, this one again acknowledges the sovereignty of states over their airspaces. And this agreement makes a distinction in between commercial airplanes and military airplanes. Military airplanes are fighter jets, for instance. So war airplanes, fighter aircraft. And it says that 44 Chicago Convention is only dealing with commercial airplanes. This is the first thing. Secondly, 44 Chicago Convention says that commercial airplanes are also divided into two, as scheduled flights and non-scheduled flights. And they are regulated by different, they're regulated by the same regime, but they have different rules of implementation. 44 Chicago Convention say that it is possible for nation states to declare no-fly zones for security reasons, for military reasons, for strategic reasons. They can call no-fly zones within their national airspaces. And as you remember, in 1919, Paris Convention, it says that aircrafts are supposed to belong to certain nationalities. And 44 Chicago Convention says how to determine the nationality of aircrafts. So at the moment, for instance, once you take an airplane starting from Turkey, from Turkish Airlines, you know that it is marked by TK and it indicates something, and they have other flight numbers as well. So certain systems are developed as a result of this idea about determining the nationality of the aircraft. Having said that, according to 44 Chicago Convention, there are scheduled flights, there are non-scheduled flights. And even though, freedom of flight is being given by the nation states to its fellow states, still all those flights are subject to certain permissions. For scheduled flights, all those permissions are taken in beforehand. That's why daylight saving times and so on should not be declared in the very last minute, because it causes a lot of confusion in flights. And those permissions are taken 2 years in advance, 1 year in advance. Scheduled flight means that we have the answers for where and when questions. Where does that aircraft take off? At what time? And where does it head? Where is it heading? When it is going to land? All permissions, because once you start from Istanbul and if you're heading to London, you start through Bulgaria or Greece, for instance. So your civil aircraft will enter into the national airspaces of Bulgaria. Then Sofia will get in touch with you saying, who are you and why are you in my airspace? Are you a threat or what? But if all those informations are provided to the states that your aircraft is going to pass through, this won't be a problem. And, from time to time we hear declarations from, let's say, they're not my sponsor, I mentioned their name a lot, but Turkish Airlines. They declare that, that would be nice, by the way, right? Anyway, they declare that new flights are starting in between Ankara and Tbilisi. We hear that. And as IR students, from now on, what you know is that those permissions are taken in beforehand, and they specify when and where those flights are going to be done and what they can carry. They specify how much cargo will they be carrying, if they're going to be carrying also post. Then, as a result of that bilateral agreement, they can load and unload. in between Georgia and Turkey. So Turkish airplane can land in the Tbilisi airport, unload passengers, load passengers once again, can load cargo once again, and come back to Turkey. And this is subject to a bilateral agreement. That bilateral agreement is subject to 44 Chicago Convention once again. But states have to regulate their flight agreements in between themselves. Therefore, bilateral agreements are also necessary. And if no permission is taken, if an aircraft enters to the airspace of another state, the first thing that's going to happen is that the radars of state B will see that airplane on their radars. So it's going to be code. And then they'll get in touch. Who are you? We see you on our radar. And if no answer is taken, this is a pure threat, right? It's entering into the territories, and defense is quite problematic once we start thinking through the perspective of air threats coming from the air. So for military reasons, anything that is not permitted in beforehand is directly perceived as a threat by the nation state, by the radars. Therefore, permissions is quite important. So we have spoken about scheduled flight. What if you have a private jet? What a problem, you know. It is that, well, first you make your decision to go to another state, and then you have to take the permissions in beforehand again, saying that next week or 2 days later, I'm planning to start from Ankara and pass through those states and land in that state, then still permissions are necessary, but the plans are done in a very short notice period. The thing is that, again, it's not only it's not that notification saying that I'm coming. It's not like that. It is like requiring permission. It's also for military strategic security reasons, also to prevent accidents happening. So if the airport is quite crowded at that hour, perhaps it's not quite possible for that private jet to land in, if they can arrange a time space for them or not, if they have the capacity for that or not, all of them needs to be regulated. That regulations are necessary for non-scheduled flights. Well, after leaving national airspaces, the airplane enters into international airspace. In between national airspaces, there are air corridors. Those air corridors are defined by the states. So they hold meetings to define the coordinates of their air corridors. And we have said that, well, there's a freedom of flight in international airspace, but this does not mean that the pilot can take the aircraft wherever it wishes and whichever route they want, whichever altitude they want. This may cause many problems and accidents. In order to prevent that, there are air corridors. And those air corridors are imposed by military or diplomatic requirements as well, for security, to prevent accidents. Also imagine, that was the case, if I'm not mistaken, by the East Germany. They were not willing to grant permissions to those flights coming from certain states. So those states had to define new air corridors in order not to pass above Eastern Germany. Eastern Germany has only granted such rights to, as you can imagine, USSR states. And also safety. That's also important on behalf of safety. In those air corridors, there are flight information regions. In flight information regions, pilots can exchange information related to the environment that they're flying in. This means if there are any storms, if there are any funny clouds that they have to watch out, or if there are bird coveys, or if there are any undefined flying objects, aliens who knows, whatever information they want to exchange with each other, this exchange of information is done within the air flight information region. And this is a communication region. Therefore, certain technical responsibilities have to be assumed. For instance, over the Aegean Sea, we can say that flight information region's technical responsibility is assumed by Greece. And if you visit the Ministry of Foreign Affairs webpage, you'll see that Turkey and Greece are having certain problems related to flight information regions over the Aegean Sea. Turkey state claims that Greece behaves as if they also own the sovereignty of the flight information region. Flight information regions are only technically controlled by certain states, but they do not assume sovereignty of that region. So what they're trying to do is enabling the communication in between pilots, in between aircrafts. That's the only reason